Well, hello everyone, and thank you, Paige. Thank you for joining us for today's webinar. Sandra, can I get you to say hello so people can get your voice?
Absolutely. Hello, and thank you for inviting me to participate today.
It is our treat, and it is to the benefit of everyone on the program that you're with us. Sandra and I have known each other since the early years of starting our companies about 30 years ago. She's an industry expert with national credentials, and it's a real treat to have her on the program today sharing her expertise on this subject. Aging in place is a real trend, and associations can create an improved future for their associations by understanding the issues, embracing these changes, and making appropriate adjustments. I'm sensitive to this topic because, just like reserve expenses, the issues don't go away if you try to ignore them. Now, as you hear from Sandra, there's some real potential problems if your association is unprepared and handles these issues poorly. Well, I hope you're ready to take some notes, but to give you some peace of mind, we are recording this program, and we expect it to be available online next week. And we'll also provide an outline for those of you who give us a couple minutes and answer a few closing questions at the end of today's program. We do this program for your benefit, and we want to hear from you and find out what you'd like to hear more of, what we're doing well, so we can shape this and be a great information resource for you. Well, Sandra's going to start today's program, but I wanted to first remind you that if at any time you have a question for Sandra or myself, as Paige said a few minutes ago, you can simply type that question into the dialog box similar to the one you see on your screen. And actually, the last time I saw Sandra face-to-face was at a program that she was doing, and I know that we both enjoy speaking to a live audience, so if at any time we have a question for you and want your feedback, we'll ask you to raise your hands, and you can do that by clicking the hands raised icon on your control panel. So let's practice that. Grab your mouse and give me a hands raised if you're ready for us to start today's program. Oh, excellent. Paige and Sandra, I see we got a alert and participating group. Okay, I'm going to put everyone's hands down. And without further delay, Sandra, tell us about aging in place.
So aging in place is what I consider to be a very interesting issue, and one that unfortunately I think we've been in denial for probably the last decade. Baby boomers are the single greatest majority of residents in the entire United States and also in our community associations throughout the country. And more retirees are choosing to retire in place, so to stay in their home, their condo, their townhouse that they've been in for years before. And what is most interesting is that those decisions to stay in place are across socioeconomic backgrounds, across the line. We don't have a great influx of people doing so, whether they're moderately salaried, lower income, or even wealthy. So what does it mean? What it means to me is that when you have people that are aging in place, it's going to affect the infrastructure of your community at some point, from gated communities to high-rise condominiums to modest townhome communities. And it's important to be aware of the potential issues and how to address this before you have incidents. One of the pitfalls that we are most concerned with is we do not want our associations to engage in disparate or discriminatory conduct where a person who is aging in place will be able to assert that they were treated a certain way, less desirable than they would have liked because they were more senior in years. So we have to be very careful to make sure that we don't cross that line. When you are dealing with anything such as a particular class of people or persons who might have disabilities, because our aging in place homeowners may also have physical infirmities that need some sort of accommodation, this is the moment that you really need to speak with association legal counsel to make certain that not only is the association protected by the actions of the board, but that you're getting the best and most up-to-date advice on how you should do what you need to do at your community. Robert, let's go on to legal related issues. the things that we are already seeing in our communities when people are aging in place is the inability to properly clean their unit. And some of you might think, well, what's it your business? That's the inside of somebody's unit, and it's not common area, and you really shouldn't have a say about it. And when I say unit, I mean home or condo unit or townhouse condo unit, even stock co-ops as well. They can create smells just from the dirt and negative externalities. And this can happen through sinks full of dishes, accumulated waste in the unit that doesn't make its way to outside garbage bins, and clutter. Hoarding is a actual disability. It's part of a mental issue that keeps somebody from being able to compartmentalize in their mind things that should be discarded and things that need to stay in their unit. And so therefore, everything winds up staying in their unit. And hoarding has created many problems at associations because of a fire hazard, vermin, mice, rodents, bugs. And unfortunately, we have found probably in the last 5 years that this has led to issues with mold, which again can lead to odors and other issues. If a senior has an in-place person the inability to care for their unit themselves, it is unlikely that they will be able to effectively care for their pet as well, and their pets can create nuisance and smells and etc. We also may have sound pollution in communities where people are aging in place. Elderly people tend to lose their hearing, and this can mean loud neighbors, people who may not be wearing hearing devices or who are wearing them, but they are not as sound sensitive as maybe one would like. And so they wind up speaking to each other very loudly, and they have watched television with the audio on at a high volume. And so now we have this audio pollution that people complain about because they're not getting the quiet enjoyment of their unit. And we do have to worry when people are unable to care for the interior of their unit, how that's going to affect other units or other buildings or our community association neighborhood as a whole, because these improper maintenance can lead, as I said, to the water and other issues. I have some other legal concerns, Robert, that we can address as well. And maintenance of the exterior of the property. So this is generally more of a concern for planned developments, but also can be an issue for any type of community association. Aging residents may be unable to maintain the exterior of their units, their yards, their gardening, which is a problem in associations where there are aesthetic guidelines and architectural, hardscape, and softscape requirements. And they may be unable to perform what we call basic maintenance of their building structure, presuming by that comment that they are obligated for the external uptake of their structure, but they may not be able to care for their yards. Their units or homes can begin looking run down and create a nuisance or a visual blight in the community. And of course, there's always the concern that you may not particularly want elderly people to do things which could result in their physical injury. So that's a legal concern as well. And do we have the right to project that somebody can or cannot do something if they say they can? And then when we deal with aging in place, another very large issue for us is dementia and forgetfulness. Well, we see that being an issue in our community associations is their forgetfulness can impact the building and their neighbors. We've had situations where an owner starts cooking and forgets about it and potentially can leave the home. We had a 4-unit building burned down by this very action. Fortunately, nobody was hurt, but the units were a total loss, as was the building structure. And the fire had significant impact on the community from both the liability and the financial standpoint. The other issue that we have is with leaving water running. And this is a major concern for associations as well. Water, as we know, can cause significant problems, and again, related issues can result in mold in the walls. So probably one of the biggest issues is what to do when somebody chooses to age in place, and the truth is they should not actually be there. So we want to go into reasonable modification requests. We have to be always mindful of fair housing and the Americans with Disabilities Act. And although, as a rule, the federal law for the Americans with Disability Act, also referred to as the ADA, do not apply to homeowners associations other than master community associations where the public, as opposed to just the members, are invited into the community. We need to be mindful of fair housing requirements that prohibit associations, appropriately in my opinion, from discriminating against somebody because of a modification request that they may make. So the fair housing laws talk about discrimination in housing, and you might think, well, how does that apply with to an HOA? We're not a housing provider. And although we may not traditionally be a housing provider, the Americans with Disability Act, both at the federal and state level, fair housing laws, specifically refer to the association as a housing provider, and all the potential actions for discrimination can land on the association's feet. So we need to be very careful to be fair, informative, and make decisions that are in the association's best interest without compromising the person who is asking for the reasonable accommodation. So I would like to distinguish the difference between a reasonable accommodation and a reasonable modification. The accommodation is a change or an exception to a rule or policy that applies globally to everybody in the association, and this arises from the resident's disability. And note that I use the word resident because it would apply to the residents and owners. So it could be a tenant, a guest, an invitee. Reasonable accommodations is separate from reasonable modification, because a modification is a structural alteration made to the physical premise, whether it's in the unit or the association common area. So if you look at the screen, you see installation of handrail or ramp, flooring. Let's say an association has a no hard surface flooring rule, and somebody who's aging in place needs to use a walker, and they are unable to navigate over their current carpet, and there are no alternatives. Although the association does not have to allow hard surface flooring or marble flooring, which are going to create the most sound transfer issues, there may be some other flooring other than carpet that the association should consider. Handicap pool lifts, huge issue. One of the things the National Fair Housing laws try to do is give people who might have a disability or need assistance the same ability to experience their unit and their home as able-bodied persons. And then, of course, there's an accommodation for persons who are deaf or blind. That comes up with flashing lights and whether we can have something installed in association common area hallways. So looking at our next slide, how should the association deal with potential issues? It's important, as I mentioned, to avoid disparate or discriminatory treatment, and that means you have to really deal with everyone on a level playing field. And you are going to address these aging in place and or aging in place with disability issues the same as if you had a formerly able-bodied young person who is also asking for the disability accommodation. You cannot make a person feel compromised because they are asking for assistance, and you certainly can't ask for information from them that you would not be able to ask for from somebody who is younger. But we do have an obligation, and this is really, Robert, where we get into problems, because the board / association has a duty to enforce the governing documents, and they have an obligation to do it equally for all owners and to act in the best interest of the association. And when we deal with these accommodation issues, we are looking for ways to make exceptions that don't harm the association, but certainly help the requesting owner. We have dealt in situations where other owners are very unhappy when the association spends any money to assist somebody with their accommodation modification request. And the answer is to those persons, I'm sorry that you feel that way. You bought into a community, and this is part of our obligation to make sure that everybody is dealt with equally.
Well, Sandra, let me interrupt. Sometimes isn't it just inherently unfair to live in a condominium association? First floor owners pay for the elevator, and there's often a few percent of owners that are breaking rules. And so people have to let go of the idea that it's going to be perfectly fair. Maybe is that a basic concept?
I think it is a basic concept when people complain at board meetings and they say, you know, we want to participate and be able to speak every time the board votes on a motion. And I have to say, and I mean no disrespect, but it is not a democracy when you are on the board and you're making decisions for the association. So everybody doesn't always get fair treatment.
Right.
The reason that we are making a point of dealing with the accommodation issues are even if you are lacking in the heart and soul in caring for those persons who are aging in your community, you have federal and state law requirements throughout the country that mandate you engage in this behavior. So you're right. We should consider that it's not fair equally for everyone. And also keep in mind that boards of directors have the abilities to make variances. So we may have very clear governing document requirements, but a board can make a variance in response to a request. And as I stated, under federal and state laws, will have an obligation to do so. One of the ways to keep boards of directors and their managing agents from making mistakes is look at the issue, meaning the conduct that either is happening or they're requesting to happen, as opposed to who is causing the issue. Associations get into trouble all the time on the flip side to aging in place with younger persons who are children. And instead of talking about keeping noise levels down after a certain time and keeping commotion out of the recreation areas, such as pools, they develop rules and regulations that say no children in the pool between the hours of such and such, and children may not make noise in the association's common area. They could deal with the effect of that, same as we have to deal with people who are aging in place, without having to identify the who that is actually making that request. And one of the things you have to ask is this conduct that we're even talking about a violation? Well, it could be a violation if somebody is asking to install a chairlift on an external staircase up to their unit. We now have other homeowners who will be complaining they lose half the width of that staircase, and they have to look at what their opinion is an unattractive additional device. And the answer is live with it, because your aging in place owners have the right to make that request and demand at their expense, subject to the association's architectural guidelines and approval. We have to do it. So we might as well figure out a way to do it without alienating both our persons who are aging in place and the people who are there living with. So when we have agreements, by looking at the next slide, for accommodations and or modification, one of the things that we want to do is avoid potential liability. So when you provide a reasonable accommodation or modification, I'm going to recommend that the association enter into covenant to be accepted by the owner and to be recorded against the property. If we have somebody who has a physical disability that literally qualifies as a disability under your state and federal law, they cannot be charged a fee or cost to accommodate their needs. So you could require them to sign a covenant, but you cannot require them to pay for it. On the flip side, if we have a person who is a senior baby boomer who is requesting this modification or accommodation, do not have to accommodate their disability. So they will sign the same covenant, which I'll explain in just a moment, but they can be requested by the association to pay the legal fees to actually do that. A covenant is a condition that runs with the land, just like CC&R's covenants, conditions, and restrictions. And what it does is it gives the world notice of who is responsible for this and who is responsible to take care of it, to repair, maintain, and replace the component. And so we like those obligations set out, especially when there might be additional owners that come into our building. The covenant will tell us clearly who is responsible for maintenance and costs. It will bind future owners if the modification is not removed upon the sale or transfer of the property. And it will be very clear on what the owner's obligations are at the end of their tenancy and ownership of their particular unit or home. And this applies to planned developments as well. It can apply with all kinds of decking up to units and ramps and all of those things. I think that is important to know that we should be looking at these issues now as if they were burning questions before we have to deal with it in the eye of the storm, which is going to, frankly, ramp up possible legal costs and liabilities and may result in our not being able to meet the obligations of timely responses to people who request an accommodation and a modification. So there are some cheating ways to figure this out as well, and I address those in our next slide. And that deals with options for what we can do to get on the front side of these issues and obligations. When we deal with issues of persons who are having difficulty living on their own and meeting their obligations to themselves, their unit, and their community at large, we frequently find that the association has no information on any family members, caregivers, clergy, anything that would help the association to reach out to get somebody to help the board of directors and management to accommodate and make certain that this aging baby boomer is safe in their unit. And when we have these health and safety concerns, if there's a contact for a best friend, a child, a nephew or niece, it will assist in many ways because the association will not have to go first to social services, but rather can go last to social services. If there's a caregiver and you have a gated community, you're going to have the information on the caregiver. You should have contact information as well. But in a non-confrontational way, you will ask your homeowners for this information to let them know this is about us trying to protect you in the now and in the future. I think it is also important for boards of directors to invite in local organizations who can help in identifying what a person could do to stay in their unit, since it's their choice to age in place. There's a huge number of organizations that deal with elder-related issues, and I really recommend that both boards and managing agents avail themselves of the knowledge that these organizations can bring to your boards as you develop your own protocol at your association. I have a Sandra-ism, and it applies to almost everything I do, and it is, if you touch it, you own it. And this may be true here. You're touching it and you own it, even though it is somebody else's issue, but you don't have any choice. Beyond the basic good neighbor policy of people who have lived together for many years until it becomes difficult for their baby boomers as they're aging in place, you may have to touch it and own it from a legal perspective. And that's really why I'm trying to give you the full impact. in any issue where there could be claims of disparate treatment or discrimination, and really that's going to be any accommodation or modification request, that is the moment you are going to use your association's budget and utilize association legal counsel. One of the most important reasons is because there are no do-overs, meaning if your initial communications inadvertently contain terms of discriminatory conduct or intent, you can't correct it later with a, oh, I meant to do this and I meant to say that. It's there and we have to deal with what was said. And instead of dealing in a positive way going forward, we're cleaning up a lot of problems that, frankly, we were trying to avoid. So, Robert, I see on the next slide you have some amazing graphics.
Well, as I was preparing for this talk with you, I started thinking of my own life and how my first home was a small condo. Then when it was time for me to be married, I got a medium house, still living in a big house, but the kids are grown, and my wife and I are talking about finding a smaller place to live. And I'm reminded that just a few years ago, my parents downsized. And so I realized home is not static, and our lives are not static. And this is an issue for community associations that's very real. I think too often we think of the association being a static thing, a 60 unit or a 200 unit association. We have one pool, and just even the terms I use right there, we have one pool, and it sounds static, and you realize that all the people within it are changing and evolving, and the association itself needs to transition some. And on this particular topic of aging in place, I picked up so many graphics from the internet that I'm just showing you here, that this is real, and we need to start to appreciate that community associations change. And the question is, well, what costs the money and who's going to pay for this stuff? There are some of the things that, well, I've grouped it into three different categories. There's operational versus physical changes, and once it's a physical change, there's a question of, is it common area versus separate interest? And then that helps define who pays, and then finally when the association pays, where do you get the money from? So let me just spend a moment or two walking through those. The operational costs are generally not too large. They're minor adjustments. It may be the manager just reaching out, creating forms, gathering information on additional contact people. There's a lot of overhead that managers do, and this may be just a little more time that things take, but this should be a gradual and minimal increase in operational costs that the association has to deal with, or maybe it's just absorbed in the manager's salary. If it ends up being a physical change, the question is, where is the change? Is it in the separate interest, or is it in, I mean by that, inside the home, or is it in the common areas? So it's going to take us down another decision path. So if it's in the separate interest, in general, the unit owner pays. They're reconfiguring their home. And in general, Sandra, correct me here, they have no obligation to restore to the original configuration. That's up to the next homeowner, right?
It'll be up to the next homeowner unless they have made some structural modification with the association's approval based on an engineer and architect's input that the owner pays for. The original approval might be limited to the use of that area near the structural component in the unit in a certain way. And because of a specificity of putting together a plan to maintain the structural integrity of the unit, they may require, they being the board, for that to go back to its pre-modification position on the change in the unit. Other than something that would affect the common area or including a structural component, you're entirely correct. It would be between the owner and their new owner.
Yeah. So as you go into a hotel, sometimes maybe I'm the single businessman. They give me the odd room, the one by the elevator. Sometimes I end up getting the disability-friendly unit with different countertops, different shower enclosure, and actually that may be a desirable asset for that unit. So it may be a good thing, not something that they wish to restore. When we get to the common areas, it's the same kind of thing. Sandra, I believe you addressed that the association wants to draft some additional covenants and agreement to indicate who's responsible for what, for maintenance, for ownership, and a responsibility, but not necessarily the requirement to restore it back to the original configuration, because you realize, wow, that may be a good thing. And even though it only affects that one separate interest, the association gets to say what it's going to look like. It needs to be compliant with the look and feel of the association. And in general, these types of things are paid for by the separate interest. And let me show you here. There's difference between, in a townhome situation, an entry ramp that someone cared to match, if you can see my mouse here, the railing to match the trim of the house. That's a job nicely done. Or it could be something that just looks like it's slapped up on a weekend, or something that's in disrepair. So if it's common area, the association does get involved setting the design standards, but in general, things like this are paid for by the separate interest. And if it's in a...
They are, but Robert, I just want to say that if we're looking at the bottom right-hand corner of the screen, I look at that as a trip hazard, because we don't know if that's a common area sidewalk that the bottom part of the ramp is encroaching on.
Right.
And in this particular situation, the association can take, if the owner refuses to make any modifications, can take matters into their own hand. They're not going to take the ramp out and then have to deal with an ADA or fair housing lawsuit, but they are going to deal with that like any other unit where compliance with the architectural standards are required.
I like that last phrase, just like any other thing at the association. When an owner does something that's inappropriate, the association gets to, needs to, and the board is responsible to care for the assets of the corporation and look after the best interests of the corporation, which may be the 100-unit association, and that trumps the one person who did something inappropriate or foolish or not quite compliant with the architectural plan that was approved. And when it's in the common... Go ahead. Okay, fantastic.
No, I'm just saying that agreement, right on.
Fantastic. And if it's in the common area and it serves all owners, I think of one of my clients that had just recently put in a ramp between the clubhouse and the pool deck, things like that. I look at that and I say, wow, that should have been there from the beginning. That's a great idea. The architect missed that 20-some years ago. So when it's serving all owners, the question is, out of what pool of money do you pay for something like that? So if it's a common area asset in general, we need to protect the reserves. And I say that with a sigh, because most associations don't quite have as much reserves as they should have on hand, so we don't want to see that as a available pool of money in which you dip too easily. Basically, reserves are for maintenance, repair, and replacement of existing assets. In general, a capital improvement, a new thing, you fund from operations or special assessments, loans, things like that. And then you have to start to think, what is in the best interest of the association? Something like a ramp between the clubhouse and the pool, that's a great idea, and that may boost the value of the association, or even having a disability assist on the front door of the lobby, make it more accessible to all the owners. And then some of these things really aren't all that expensive. Pool lift can be relatively inexpensive. A little ramp at awkward door sill can be inexpensive. And then we get into the question of, again, from what pot of money do you pay for this? And I just want to show this. We have a decision guide. It's not always clear, but a couple of the issues that I want to point out are, it tends to be a reserve expense if it's a natural evolution of an existing asset, like disability assist on a lobby door, when you're in the process of doing a lobby remodel, or if it's an integral part of a system. So it's not an awkward thing all off by itself. If it's part of a system, a lobby system, an entry system, then we tend to lean towards it being a reserve project. And I just want to start to wrap up by saying that it's not always clear, but fortunately the boards out there can get wise counsel, and that means check with your reserve study professional, check with your attorney, as Sandra said, and then you have to realize that aging in place is happening. The association isn't a static organization. The association is not required to accommodate the changing needs of owners, but as the people change, they may want to adjust the association to fit that. There's going to be some costs, and consider that the changing demographics mean that there may be some appropriate physical changes, just like we've done in other areas. There's so many associations out there. I can go back in my time and remember when they had a key-based entry system, and that went to a telephone-based entry system, and now we have fob-based proximity readers or key cards. So just like technology changes and the owners change, the property may need to respond and change appropriately. So it's an issue that's in flux. And fortunately, as I look at the time, we're about at the time that we've allotted for today. On behalf of Sandra and myself, I want to thank you so much for taking a little bit of time out of your day today to start to see the future and understand that this is an issue that is very real and is going to be facing more and more of us, our families, and the community associations that we touch. For future reference, I want to encourage you to visit Sandra's website at Swellison and Gottlieb. They have some great resources there. You can sign up for their email list, read their blogs. It's all at lawforhoas.com. And on the financial side of things, we help associations see the future and prepare for it. You can go to reservestudy.com. We have a learning center there, again, with lots of articles. You can request a proposal, join our email list. But bottom line is we hope we're able to see the future just a little more clearly. It's out there, and gain a few insights about things that are changing at your association, how you can prepare to adjust for those changes. As Sandra said, don't wait till the last minute. Start to get a sense that these things are going on, and start to nod your head and say, yes, this is real. So at this point in time, with a few minutes of time remaining, I'm going to turn the microphone over to Paige, who will serve as an MC for a few minutes of Q&A. Paige.